you for tuning in again tonight. We have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. I want to tell you a story about a trial that I had last week. It's a very complicated, interesting trial. But this topic is going to be, like the name of the show is Affidavit of Non-Prosecution. And I'm titling it that because my co-host today is Teana Watson, who's a lawyer.
Hello.
And I have a first-time court watcher named Rosalyn Joseph that's here tonight.
Hello.
And many times we get letters from clients saying, oh, this guy's going to give us an affidavit. Or if there's a victim, especially a domestic violence complainant, a person that said they were hurt, they'll give affidavits of non-prosecution saying they don't want to prosecute. So I want to talk about that through a story and a trial that I had where an affidavit of non-prosecution had been filed. So let me tell you the story. I have someone that came to me in 2011 and he said, I've been charged with kidnapping. And it's just strange because I didn't kidnap her. I mean, she's my girlfriend. I've known her for 3 years. I've dated her for 3 years. The problem is I was married most of the time and no one was supposed to know. And we had a date that night. I was waiting out of the window, looking out the window like I always do. And I saw her drive into her driveway and then get in the car with someone else. I didn't know who the person was, man or female, but it was just something strange because I knew she was really drunk. So I followed her. And when I followed the car, they went to a store not far from the house, and I saw the guy get out and go inside, and she's still sitting in the car. So I want to know what's going on. I mean, why did you text me tonight that we're going to have a date after you come in at 2 o'clock, 2:30, and then you leave with someone else? So she got out of the car with me. They're arguing, they're going in his truck. He has a big truck. They're arguing in his truck. He's scared he's going to have a wreck. It's late at night. He stops by the side of the road, and they get out of the car, and he just says, look, I'm just going to leave you till you calm down. And little did he know she has on these 6-inch high heels, and she's really drunk. She tries to grab onto the truck. To make a long story short, he looks in his rearview mirror. He sees her laying on the ground. He goes back. He picks her up and doesn't know what to do because she's moaning and groaning. He doesn't take her immediately to the hospital. He takes her to his mother's house because she lives close to a fire station. They call the fire station. EMS comes. They take her to the hospital. She has awful injuries. I mean, she's broken her pelvic muscle. She has her pelvic bone, internal bleeding. I think her bladder's torn, tooth knocked out. I mean, just all kind of injuries all over her body. And his mother drives his truck to the hospital. Well, the guy that she was with, remember, he comes out of the store, she's no longer there. He tells the police, now he's drunk and high too, he tells the police, hey, she's been kidnapped. Someone told us she was kidnapped. And so the police are looking for her. They basically have an APB out on her. So she ends up in a hospital. So obviously they think that my client has kidnapped her. And no one knows because they've been having this secret affair for 3 years. The family doesn't know that they actually know each other. So it becomes a situation where he can't talk to her for 60 days because when there is some domestic dispute, there is a 60-day emergency protective order issued by the district attorney's office when charges are filed. He was charged with kidnapping that night. So when he comes to my office, he tells me, Ms. King, I didn't kidnap her. I know her. He tells the story that I just told you. And we've been together for 3 years. This is crazy. We fight this from October of 2011 all the way until February of 2013. Eventually, after about a year and a half, we are already set for trial, because it's crazy, because to kidnap someone, this is what a person has to be guilty of. You have to say that, let's talk about kidnapping. Okay. Kidnapping is when you abduct someone and take them without their consent, against their will, to another location. All right? So the issue is, did he abduct her? Did he take her against her will? Well, it takes us about 6 months, 9 months, but we get the store video, and it's grainy. It's not a good video, but you can tell that she's getting out of the car herself, because you can see him move out of the way when she opens the car door. So this is why we're fighting the case. And when we get to trial, my co-counsel is Teana Watson, who's here in the audience, and we're going to talk about the affidavit of non-prosecution, but I want Teana to talk about some of the facts of the case.
Well,
fill in.
I will. I want the listening audience to know that actually this complainant was, I would say, run over by the vehicle. And these injuries were very, very serious. Now, the issue was whether he intentionally, knowingly, or recklessly ran over his girlfriend, or whether it was an accident or not. But her injuries were consistent with this big truck running over her. And because the injuries were so serious, because it was a domestic violence case, a case involving boyfriend and girlfriend, you have a lot of issues where the district attorney's office feel they have to protect the complainant. They have to make sure she's not being threatened and that she's not in a relationship where there will be further violence. So there we have the 60-day emergency protective order to prevent any violence. And the DA's office and their staff, they're very trained at making sure that you go forward with the charges and that you really stay strong so that this person can be prosecuted that hurt you. And so they...
But let me just correct you on one thing, Teana. Teana was gracious enough to help me in this trial, but one of the mindset I want the audience to understand is that for over a year, we were only fighting a kidnapping. So although her injuries were very severe, had we been fighting both cases at first, we might have had a different result.
That's correct.
We might, you understand what I'm saying? So it was already set for trial, and then they added charges to make him plead, to try to make him plead guilty. So that did change the dynamics of it, but it was never what we were investigating in the first place.
And that's interesting. I wasn't in it from the beginning, but that's exactly what can happen. If they feel they have, the district attorney's office feel they have a better chance with a more serious charge, or a charge that people could definitely wrap their heads around, they're going to throw that charge on. Even though your original charge was kidnapping, they're going to use that more serious charge to get you to plead to something.
And that's the part that becomes a little bit unfair, but because think about this, for 1 year, we're setting something for trial for kidnapping only. We're ready, we're there, we've studied, we know that they can't make this because the girl has given them an affidavit of non-prosecution and an affidavit of actually what happened and going into the lengthy relationship and that I went willingly. So it's kind of a no-brainer for us to go to trial. Why plead guilty and take 5 years prison time when this is your girlfriend and you didn't take her? So we have one trial date, the DA figures out a way to get out of that trial. I'm ready. We have another trial date, they figure out a way to get out of it. The second or third trial date, and these are coming in increments of like 3 months, then they say, oh, judge, because he gets to us. And the prosecutor goes up and says, oh, we're going to re-indict it.
Wow.
So let her get her, and when a case is re-indicted and additional charges are filed, the lawyer gets an automatic 10 days to prepare for these new charges they have to fight. So we're there to fight this kidnapping. We're ready. The second time, the judge calls us, y'all are up. And the DA says, oh, we're adding an additional charge, aggravated assault with a deadly weapon, which is a more serious charge, and where all the injuries are. Because, and the thing that becomes patently unfair to me is that when you arrest someone, you arrest them for kidnapping. If you find that that's not it, to me, you let them go. You don't say, I have to get you for something. And that's more of what the DAs do. And that's not good, because the DA's oath, which is in our Code of Criminal Procedure, says it's not to convict, but to see that justice is done. It's not to convict, but to see that justice is done. I took that very seriously as a prosecutor and thought about, am I just being, am I being vindictive, or am I taking this personally, or is this the best thing for society and for the victim? And what frustrates me is about half the prosecutors we have do not think that way. They do not think, is this the best for society? Am I just trying to get a conviction for all costs? Because that's not my oath, that's not my pledge, and that's not what society expects of me.
Sure. Sure.
And so so we got into a trial situation because he definitely drove off. They had a history of fighting, and she had put him out of a car before. He put her off to calm her down. He was going to make the block and go back and pick her up. Many young couples have done that. I've done that in my young days, gotten put out of a car. So, because we're being irresponsible. Who would ever imagine these horrific injuries?
Sure, yeah.
And no one knew how they happened, because she's extremely intoxicated and high, and he's not. And then everybody's speculating. So an aggravated charge, as you know, will carry with it prison time, and you have to do half the time on aggravated. So for anything that says aggravated, if you get 20 years, the person has to stay in jail 10 years before they're even eligible to talk about getting out on parole. Where the kidnapping is not aggravated because there's no weapon alleged to have been used. So they don't have to go, they're not under that same guideline. But the problem is, this is not a kidnapping, because the person who said kidnapping, who is the boyfriend that was with her, the prosecutors don't even call him to court.
That's correct.
So he's not even there. The person who starts this kidnapping story that the prosecutors have to hold on to doesn't even show up. They don't even call him, because they know that I've told them our side of the story. So the prosecutors know that this guy is going to say, well, that's what I thought, because I don't know why she would disappear out of my car, but I had no really proof of it. And I lied when I said someone came in the store and told me that, because once we got the store video, we saw that nobody came in the store and told him that.
That's true.
We knew he lied. And he said she was kidnapped by a guy in a red truck, and it could have been a guy with dreadlocks, because we saw him at the club earlier that night, where our client does not have dreadlocks, and he drove a black dually. So
right.
all the information that the reportee reported to the police was wrong.
Correct.
So the prosecutors don't even call him in. And another reason why we were going to trial is because the government cannot take your liberty without being able to prove a case beyond a reasonable doubt. And here we have a reportee who is reporting a crime, and it doesn't check out that night. It doesn't check out. The vehicle's wrong. When we get the video later, there's nobody reporting anything to him. He just kind of made that up because he's shocked that she's not there when he comes out.
Sure.
And her purse is there. Her purse is still in the car, because she leaves with her cell phone and not her purse. So Teana, make some comments about that.
Well, I think that what the prosecution did is they threw everything up. And unfortunately, they could, because the injuries were severe, and because they know those types of cases, boyfriend and girlfriend cases, where there's injury, even though the complainant may come back later and say it didn't happen or it happened differently, they still have the moral high ground. This is how the state feel, and going forward with it and saying, look, we have to protect her. We have to protect her. So what they did, quite frankly, is they stacked the deck against you and made it very difficult to fight the charge. And it's unfortunate because, like you said, it was a kidnapping, but they saw they had these severe injuries, and they know the dynamics of the relationship.
And they know they couldn't make the kidnapping.
And they know it would be extremely difficult to make the kidnapping.
Extremely difficult, because she's filled out an affidavit of non-prosecution, which basically, I want to read that just for the viewers to know. You have to say that you're over 18 years of age. I am the complaining witness against the defendant in the case. It is my wish and desire that all charges in relation to these matters are dismissed, that there be no further action taken, and that I do not intend to pursue prosecution of the defendant. I would further express my desire and intention not to appear as a witness against the defendant in any court of law pertaining to this matter, and I would request that I not be subpoenaed to do so. I am making this affidavit not on my own free will and not to frustrate the ends of justice, nor have I been offered any benefit to testify falsely, to withhold testimony, or to elude the legal process. And so they swear to that and get that on file. People do this every day. Sometimes the prosecutors accept that and dismiss a case, and other times they don't. It's very frustrating from a lawyer's standpoint to say that what the prosecutor's going to do. So, Teana, if you give if one of your clients' wives or girlfriends gives you an affidavit of non-prosecution and they say, well, it should be dismissed, how do you deal with that?
Well, a lot of times I make it clear that, of course, and I know you did in this case, I did not assist, and I make that clear in any way. I have had complainants or wives or girlfriends express that that's what they want to do, but I try my best to stay as separate from the process as possible so that it does not appear in any way that I have intimidated them, of course, or influenced in any way. However, if that's what they want to do, their wishes should be made known, and they're told exactly how to engage that process. They can hire their own attorney. In some cases, that's probably advisable when there are records, privacy issues, and other threats that are made. For example, sometimes some DA's offices threaten the complainant that if they were to come back and say it didn't happen, they're going to file a false report on them. And so many times that's probably what's advisable, is for them to hire their own attorney. At any rate, I try not to assist them much in that process. If they were to file an affidavit, I do ask that I have a copy, just as the prosecution has a copy, so that I'll know what it says, and go forward from there. Sometimes it works and sometimes it doesn't. It totally depends on the prosecutor, the facts, the complainant, the defendant, and what happens to the case, the outcome of the case.
And I wanted to talk about that because I get, in half the cases I get, people say, well, I can give you an affidavit. It could be a drug case. And they'll say, well, I can give you an affidavit of who it belonged to. And that doesn't work out. I can get, so I want to talk about affidavits because some of my clients will come to me and say, well, Ms. King, you're not trying hard enough because this affidavit is going to do something magical. Now, because you were a first-time trial watcher, but this is kind of off the topic, what do you think I can do with an affidavit? Because someone said, if I get an affidavit, what do you think magically is going to happen? And I give that to the prosecutor.
I would hope that the affidavit would stop the process from going forward.
Right. And that's what people think. That's what people believe. And we try to explain that that's not the way it works. That's not the way it works at all. It does not stop the process. What did you think happened? What did you think about the case when the complainant in this case testified that it didn't happen?
I remember her saying, the prosecutor asked her, did you want to be here today? And she said, no, I don't want to be here today. You know, several times I've told you that I didn't want to press charges, and, you know, I'm still here, you know, and they really didn't care much about her not wanting to be there.
And also, what did you think, just in watching the trial, you're the aunt of the defendant in this case, and you watched the whole trial other than jury selection. Tell me about that experience for you, just as a person watching a trial and not knowing really how it works.
I thought that it was a very stressful situation, I guess because, you know, my family was there, first of all, the person on trial. Secondly, just to hear the facts of things that I didn't know that were taking place. Third,
you're talking about like the affair?
The affair, just his involvement with her altogether, you know. And then when you hear people tell lies about the person that you love, stuff that you know that's totally out of character, but, you know, and then I have to think about, well, the whole affair was out of character for him, you know. So, I mean, it was shocking, hurtful. It made me angry at some points, you know. So I guess I had mixed emotions about the whole thing.
Now, when you say you heard the prosecutor tell lies, what are you talking about?
Well, the prosecutor, I remember hearing, I can't, just say exactly what I did here, but I know that during the closing arguments, she said things that were not even testified by any of the witnesses. Things she said brought up certain points that was not even discussed during the whole trial process. And I was like, man, she's adding stuff in there, and how could she do that, when that's not even the truth,
And what did describe the prosecutor's demeanor to you?
A lot of times she was just outraged and angry, about the testimony. If some, like the person that, the victim, well, if the victim wasn't saying things that she wanted to hear, she just got very emotional, very angry. You could see the anger on her face. Her face was just angry, and I was like, wow, she's taking this really personal. I mean, because if I'm telling you that these things didn't happen and you're trying to make me say that they did happen, I mean, what you want me to say? And that's pretty much when she just got very, do you mean to tell me that this didn't happen? And I was like, man, I mean, the girl said 50,000 times already that
she lied.
Yeah, And so, she was just very adamant about trying to make the story her way instead of the way that the victim said it went.
I think that's one of the more disappointing things for me in trying cases in the criminal process is when the prosecutors write the script for the complainant or for the police officer or for a witness and not let it naturally flow the way it is. When it becomes so personal that the story is changed, I think people come away from it not respecting the process as much. Because I remember you telling me off camera that you noticed that the prosecutor would frown up at the complainant and like she hated her, like in disgust.
In the lobby.
But yet she's telling the jury, I'm trying to protect her.
Yeah, like when she saw her in the lobby when we were on break or whatever, she would just frown. I mean, every time she looked at her, she was looking at her like that, and I thought that was real unprofessional, being in even though it's a trial setting. I think professionalism comes first, and you can't forget why we are here. And I think that she took it so personal that, it was like she had a vendetta against the victim at this point that, okay, well, you say it didn't happen, I'm going to make sure it happened. I mean, you could almost see it happening. Now, her, the co-prosecutor.
Let me just take a call right quick.
Okay.
Caller, thanks for calling Truth and Justice with Vivian King.
Hello there, Miss Vivian King.
Hey, Tracy Brown.
How you doing?
My number.
Hello, Miss Teana and Rosalyn.
Hello.
Hello.
So, hey, now if just beauty and looks alone would get people acquitted and get them, turn out a favorable verdict and in favor, y'all got a hand down, but y'all very talented. Now, see, I learned something tonight. And what I want to know, now, see, I've got an impression that if somebody filed charges on you or something, I thought the prosecution automatically picked it up even if they did drop it.
They do. They pick it up automatically, and if you file, but it's just the problem is half the time if a complainant files an affidavit of non-prosecution, they'll dismiss it, and the other half they don't. It just depends on the prosecutor. It's no rules for that.
Correct.
Okay, well, I learned something tonight, and I'm glad to, hear that. Hey, y'all keep on fighting a good fight, because y'all doing a good job down there. And we need some warriors down there, that's going to protect people's rights, and, because you got so many people, locked up for things they didn't do, and inadequate, counsel. So I never, have to use you, but if I do, I will get you. I don't want to disappoint you like that, because, hey, I love you.
I know you're not going to get in trouble and disappoint us, Tracy.
Okay, then.
Thank you, sweetheart. We love you. Bye-bye. One of the things that you said that was very interesting that you said, Rosalyn, being a first-time court watcher, was the professionalism. I was a banker for 9 years, from 80 to 89. I got out of college in 80. And it was such a professional environment. People might not like you. There might have been racism. There might have been all kind of things going on because it's a big world in banking. But people were always professional. And when I went to law school and went to the district attorney's office, I was shocked at the lack of professionalism because people didn't say things that were politically incorrect in the banking world. They didn't disrespect people or talk to people unkindly. But then, you know, when I was a prosecutor, I would hear my coworkers calling people, you know, poor white trash, the N-word. I mean, just all kind of things in the office, because it's a big, the Harris County District Attorney's Office is a big office, and I'd be like, ooh, you know, they might not even know that I'm there. It was so shocking how disrespectful they are to people. It's like a classism thing, and that was. I mean, I did my job, and I enjoyed being a prosecutor, but I was doing it to protect society. I wasn't taking it personally.
Sure,
you know, I was
sure.
trying to protect bad neighborhoods, make sure that it was the right person we were prosecuting, making sure that I was weeding out cops that I thought were lying, because that's a prosecutor's job. They have to be that extra layer to make sure that they're not cheating. And so it was always shocking to me when I'd find other prosecutors that would actually ask a cop to lie, or ask someone to say something that was not true, or ask a complainant / victim to say something that's not true. I mean, if in this case she lied because she was angry and she changed her mind, why would a prosecutor want to have her to say what she wants her to say? You know, I mean, that's not fair. That's the opposite of the oath. That's to convict. And the oath is not to convict, but to make sure there's justice. What is justice here? I don't know what justice would have been, but I don't think justice was this. I think that there was another way we could have gotten to a just result. Don't you think?
I think so. And I think you couple everything you said with social media now and listservs. And a listserv is an outlet where attorneys comment on cases, and it can get out of hand. They comment on other attorneys, they comment on prosecutors, they comment, and it is really the civility and the practice of criminal law has taken a really bad turn. And it's sad because it is the place where people come for justice. It is the place where people's liberty is at stake, but you have a lot of players that are not nice and that don't mind infringing, I hate to say it, on the rights of other people who are not well represented or may not have the same education that they have.
And let me tell you another thing that bothers me on the line of the lack of professionalism in a corporate environment, and I know you came from the medical environment. When I was in corporate America, there's always layers of supervision. You know, people have to behave a certain way, or they're written up, or they're put on notice. And I mean, everyone's expected to follow social office norms and behavior. In the criminal law, there's no supervisors, there's no bosses. There's layers of supervisors, but I mean, if the elected DA is mean, and doesn't care about people's rights, hypothetically, then everybody in his office, he's training them to be the same way. And who is really their supervisor?
Nobody.
Who stops a 25-year-old prosecutor, let's say 28-year-old prosecutor who's had no life experience from throwing their social norms from their good environment to people who've had a bad environment? And that's the thing that's scary about the process, because the only people who control it are the voters. And the voters don't know the truth because the media usually is going to be eager to talk about defendants every night, be it right or wrong information, but they're going to be scared and slow to talk about the district attorney's office. That's right. And lawyers are disciplined, but DAs are not disciplined for the same thing. So, you know, there's such a double standard that it perpetuates bad behavior. And what can you do? If you didn't like the way the prosecutors represented you in Ft.Bend County, what can you do about that?
Nothing.
Nothing. You feel you're helpless. And so when you have young people that are 26, 27, 28, 29, with the power of people's lives in their hand, and they have no supervisor that's going to do anything but get them, get them, get them, get them, get them, and there's no balance in justice, then we create a system that's not good. And there needs to be some type of accountability. And that's one of the reasons why I do this show, is because we need to talk about these things. We need society, who are the voters and the taxpayers, to hear a different side, because the Houston Chronicle's not going to tell you. The news is not going to tell you at night.
Sure.
because all the players are friends. And friends have a hard time criticizing their friends or accepting constructive criticism. I mean, I want to be able to say constructive criticism and still be a friend to my colleagues, and I want to be able to accept constructive criticism. But what you said about the professionalism, I'm sorry I went off on a tangent, but it's very interesting. What did you think in watching the trial about the judge's role? Because the judge is supposed to be the referee that actually listens to both sides, and when someone objects, either the defense lawyer or the prosecutor objects, the judge rules on the law, whether to admit the evidence or not, and it's not supposed to be biased. The judge is supposed to uphold the Constitution and the laws of the state of Texas and not be emotionally involved. Did you find, as your first court watching experience, that the judge did that?
At the second half of the trial, I would say he did. The first half of the trial, I thought that the judge was, I think that he was not happy with the prosecutor because it didn't seem like she had her information straight. So a lot of stuff that she was objecting to or you know, trying to make a point on, he would sustain it. And she would get angry with him, but he was mad because she didn't have her stuff together. The second half of the trial, I thought that, like when the defendant went up and he started testifying, it seemed like it was a shift had taken place by that time whenever you tried to overrule or however it goes. Yeah.
Whatever. You don't have to use the right terms.
He got angry with you, you know, and he just didn't want to hear nothing you had to say. And I didn't think that was fair. I thought that you could actually see, in my opinion, that he had changed his mind about whatever it was before. Whatever he was thinking before was different now. His demeanor was different. Seemed that maybe he was listening a little bit more intent at this point. I don't know, it was just something different.
Did you think, I heard someone say in the trial that it looked like he took sides. Did you look like he took sides with the prosecution?
He did take sides with the prosecution. He did because...
And do you think it was based on the facts or based on the fact that he didn't like the defendant?
I think he didn't like the story. You know, none of us liked the story.
Yeah, nobody liked the story.
I think that he really didn't like the story. I think that he did take some personal thought into it. You know, he used his own opinion about it or whatever his thoughts were about the defendant. I think that maybe he didn't like the victim either. I mean, he just didn't like the whole story, you know, really. And I think at that point he had just summed it up in his mind. You know what? I'm gonna do something about this because he shouldn't have been having an affair with her. She lived right across the street and they shouldn't have been doing this, so I'm just gonna punish both of them. And that's how I felt. I mean, from his demeanor, from the way he spoke, the way he
frowned at me,
frowned at you, just everything. I mean, the whole case took a shift at that second half after lunch. On that last, most stressful day, that was the day that everything took a shift. The first day was cool, you know, I probably wouldn't have even thought he would have came out with a guilty on anything, you know. But that second day, at the last half of the trial, you could tell was just an absolute shift. The whole atmosphere was different. You know, even watching the jurors, you could just tell that.
And when the judge takes sides like that, it controls the jury a lot.
Mm-hmm.
But by the grace of God, he was found not guilty of the most serious charge.
Yes, yes.
And it appears that the jury did compromise. Teana, you had something to say about that.
Well, I thought it was interesting. When we talked earlier, you know, you talked about how stressful the entire trial process is, and I kind of want to talk about, I have had clients and telling them, these are intelligent people, very intelligent people, we're going to trial, and it's going to probably take 2 to 3 days. And they are appalled because I really think most people believe it's like a TV show, it's over in an hour. And the 2 or 3 days, which is the norm for a misdemeanor and some felonies, we're usually, the attorneys, not sleeping much. We're eating, sleeping the case. I'm sure the client is probably thinking about if he's going to return home or not. And you were just the aunt of the client, and you felt the stress. And so what you find is this is real. What's happening is happening now. It's happening right in front of you, and you can't stop it. That's the other thing. So the emotions that you felt were coming out and the shifts and all that, we're in it. We're in it at the time period.
It's
and
extremely stressful. Well,
hit
that's
a
what
pause
Tina's
button.
saying. It is, when you have the weight of someone's life on your shoulders, it's extreme. You know, we don't pay attention to our own children, our own kids. I mean, and that's a very stressful job. We really don't get paid enough money to do it because you're fighting a whole system. You're fighting clerks, you're fighting judges, you're fighting prosecutors in a whole office. You're fighting 12 jurors that think they come to put people in prison to help the government. So it's an extremely, the bailiffs are there helping the prosecution. So you stand alone against the whole system.
Sure.
It's a very, and that's why we have to stay engaged in our criminal justice system. As jurors, as voters, you need to stay engaged because I don't think that a judge should take sides like he did. I don't think your personal feelings need to get involved, especially when, all in all, everybody knows that those crimes were not committed. I mean,
Exactly.
but it's like we've wasted all this time, so we have to do something. And is that really what our criminal justice is based on? The stress is insurmountable. We were there until 12:30 Saturday morning. I mean, we didn't just stop. We were there all day Tuesday, Wednesday, Thursday, Friday, and when the jury was hopelessly deadlocked at 8:30, miraculously the judge stopped letting us look at notes, which is against the procedure, and he started writing them notes without the lawyers seeing it, which is against the procedure, and the jury came back with a compromised verdict. And at 12:30 in the morning, 12 in the morning on Saturday morning, which is appalling. I mean, that's appalling. I mean, it took me a week to recover from that. My back was hurting. Here we are standing in high heels all day.
Sure.
It was amazing.
Sure.
It was amazing. People have a lot more respect for us when they watch a trial. They understand what we actually go through.
I do.
I know you do. You tell me what you think?
I really do. You know, that's a job that I would never want, you know, but I know that even working in the medical field, that's being a public servant as well. So whenever you serve the public, and if you do it from your heart, you're really giving more out than you get in. You're never paid enough for a heartfelt calling, you know what I'm saying? But I tell you, that's a job I would never want. I mean, you're fighting against all these people. You're wondering, you have to be wondering if I'm going to win or not. Did I do a good job? And then,
well, what did you think we did?
I think you did a great job. I really do.
And tell us why you thought we did a good job.
I think that you brought up some very valid points, especially being that the person who started the whole mess wasn't even there. I'm still wondering where he is. You know, you make these accusations and then you're nowhere to be found. To me, that person, it shouldn't even been a trial just based on that in the first place. So it makes me wonder, was it racially motivated? Are you just trying to teach these young kids a lesson because of infidelity and, you know, just a lot of stuff going on between them? Or, I mean, it's a better way to teach a lesson than to try to put a person's life in confinement, especially when they have a family, you know, children.
What you learn is that we definitely have to watch who has control of our liberty.
Exactly.
Because you want people with good judicial temperament. That's a term that we use. You want them to have a good attitude towards it. I think judges should always stay fiscally engaged in how much it costs to incarcerate a person. Do we really want to spend $50,000 a year incarcerating this man who works, takes care of his children, and who had an affair which is morally wrong, which he has to pay for, but yet there is no kidnapping?
Correct.
There was no intent to hurt anybody.
And can I say that, you know, that's the moral part of it. That's something you're going to have to pay for anyway. You know what I'm saying? But to be that engaged in somebody else's life that's a productive part of society, I mean, it was like he was, at first, it was really like he did have compassion and he could understand the place of this young man maybe getting sidetracked by this, you know, pretty girl that lived across the street, and maybe things wasn't so good on his side of the street, you know. And then it's like the second half of the trial, it was like he just didn't care. I mean, it was like maybe someone had said something to him to kind of deter his thinking toward the left. You know,
And why
I
do you
don't
think
know.
the judge's thinking really shouldn't have anything to do with it, since he wasn't the final decider?
Right.
But the judges do control the tempo, and jurors do take direction from the judge, not knowing the judge knows no more about the case than you do, because lawyers cannot talk to judges about cases. That's against our rules. So they know a little bit about the facts that we're fussing about, but they don't know all those details. They're learning it as they go, if
Just
they're
like
paying
everybody
attention.
else.
If they're paying attention, which, so they don't really know anything about the case other than what the actual charge is. They don't know. So when they take sides, people start thinking, if the judge is thinking that, then maybe he knows the answer. And you can have a trial just by judge. And if a person wanted that, then that's what we would have done. But we can't trust judges. We have to go to juries. And that's why our forefathers created that system, anticipating that you couldn't trust the crown, the government, because the government is going to all be on one side. So you want to take it to the people. Do you have a comment to make?
Well, and you have a right to a jury of your peers, you know, and I think that that's what's really important, because if they are your peers, then they're going to be people that hopefully are similarly situated with one or two or maybe three people with a similar experience. It doesn't have to be that exact fact pattern, but an awareness and openness and exposure to people who probably have those issues and can separate that moral issue from whether a crime was committed. And that's just so very important to have that mixture. I think that's why the magic number is 12, and it's important. And I think, do you think that the young man in this case had a jury of his peers?
I think that most people on the jury was of his peers.
Okay.
Maybe a few people were a little older from a different generation, so maybe they couldn't really relate to, you know, the things that taking place. But people, yeah, most of them were closer to his age.
And there were a lot of
say.
games that we had to play to get it that way, too. We'll talk about that in a different show. It was very interesting. I'm seeing we only have 15 minutes, so we're not going to talk about that. But we're going to talk about that. We're going to have a show dedicated to jury selection and the racial mix and how we get there.
I think it made the difference.
It made
and
the difference.
Outcome,
Tina, you talked to the jurors, so talk about that.
I did. It made the difference in the outcome of this case. There were clearly some jurors that wanted the defendant, the person charged in this case, to go to prison. They weren't even supposed to talk about that because the jury did not even make that decision, and he did not go to prison. That was not the decision. However, that's how upset they were. And then there were others who felt that this case is something that should not have been prosecuted. And so if you didn't have that mixture of people, and they were diverse people from different backgrounds, different ethnic groups, and so on, if you just had the homogenous, just the one set of people, then this young man clearly, the juror said clearly, would have gone to prison. And they were very adamant about that.
Wow.
So
but because we had a mixture of people, black people, Asian people, Muslim people,
young people,
old people, white people, we had a clear mixture. That's why they were hopelessly deadlocked until the judge started sending these notes that I never saw, but which is against the rules. But they told Teana that they really had to discuss this and they really had to fight about it because people wanted to send him to prison because they didn't like him, basically. Correct. And that's what we have to watch in this society, when we can just throw everybody in prison and we don't talk about the cost of prison and the cost of it. That becomes a problem.
And you know, it's just so easy for us to throw each other away. You know, just human beings, they pay more attention to animals than they do to, you know, the fellow brother, and that's not right. You know, I mean, I could judge them on what they're doing if I knew their business like that. I mean, what are they doing?
Let me take a call. Thank you for calling Truth and Justice, Vivian King.
Hello.
Hello.
Good show.
Thank you. I know your voice all the time, but I don't know your name. Is it a secret?
Yeah, I think that's probably for best.
Okay.
I might blow it sometimes, say something I shouldn't.
Okay, so you want to stay anonymous?
Yeah.
Okay, well, that's okay. Thank you for watching, though. You have any other comments about the show?
I guess I tuned in late, so I didn't catch everything. You and Miss Watson were co-counsel in this case?
Yes, I begged her to sit with me.
No, she didn't have to do much begging.
Yeah, she learned the facts as she sat there with me. I had been on the case for 2 years, but I asked her to sit with me because there were too many people against me, and I needed her help. She's brilliant.
So you've dealt with this judge before?
Never. Never. It's in Ft.Bend, and that's Tina's territory. Tina was a prosecutor in Ft.Bend many years ago, and she's the go-to lawyer in Ft.Bend County.
Thank you.
I was a prosecutor in Harris County. You go to me here. So I need Tina when I'm there to navigate the personalities and to help me, with everything that goes on. It was a very interesting trial. We're going to talk about it in some other shows, too, because it went on for a long time, and there were a lot of issues that we dealt with that I had never dealt with before, actually.
When you said that it was against the rules, did you mean it was against the law? Talking about the judge?
There's not laws with judges, but there's ethical rules and evidentiary rules and rules of the Code of Criminal Procedure, the trial procedure. It was against the procedural rules. And a procedural rule can get a case reversed because if you violate it, because the jury is supposed to deliberate, and if they have a mistrial, they're not supposed to do violence to their conscience. And so a judge is supposed to show us the note. It's a file marked by the clerk. Both parties read it, both sides, the lawyers and the judge. And if the judge writes a comment back, it basically needs to be approved by the lawyers, or we can object to what the judge is writing, because the judge has to stay impartial. He can't comment on the evidence, and he cannot invade the province of the jury. It's a part of our basic rules. And in this case, the judge was very angry when he found out they were deadlocked. He didn't let us read the note. It was about 8:30 or 9 p.m., and he wrote a note, like real mad to them, and sent it back to them. And from that point on, all night, I found out that they were bringing notes out that he was not letting me see.
Have you seen these acts in Harris County?
Never. I've never seen this before in my 21 years, and I called some experienced appellate lawyers. They had never seen it.
Wow.
It had never been seen before. I'm hoping.
That typical? No. I mean, in Harris County, that
never.
They're always coming up with something?
If a jury comes back and says they're hopelessly deadlocked, the next move is for the defense lawyer to ask for a mistrial, and the case is over for that day. And you start over, or the DAs decide whether they're going to dismiss it, or we go back to the negotiating block. That's what would have happened in Harris County. We would not have been there till 12:30 or 1 in the morning, to where the judge is basically holding the juries hostage. And I think at some point when the jurors were told they had to reach a decision, you don't have to reach a decision. So I don't know what the note said. And I tried to look late that night. It was never turned in to the clerk, and the clerk is the keeper of the record. So I don't know how this saga is going to end, but it was definitely wrong.
Well, sorry y'all had to go through that.
Thank you for calling.
Thank you.
So we have about 10 minutes left. What do you think will be an interesting item to add to further to this discussion tonight, Teana?
Well, I think that people should stay mindful that the criminal justice system, or just the judicial branch of government, is important to our democracy. And they have to participate in it just as they have to vote, because it's important as a citizen. It's an important right you have, and you need to see what's going on. You were a casual court watcher because this was someone that was near and dear to you, but people need to see who are in our courts, how they're functioning, and everybody. The prosecutor's actions, the clerk's actions, the bailiff's actions, the judge's actions, everybody's actions should be able to sustain scrutiny if it has to. I think it's important.
And there were a lot of things in this case that need to be adjusted. They don't happen in Harris County, maybe because we are a little bit more vocal, and it's more of us. But judges should not be able to control a process to where they make someone convict somebody even if the jurors convict you for the lesser charge so they can give you probation, it just doesn't seem like it's reversible error. I mean, it just shouldn't happen. But you know, a person has to appeal it, and they have to fight it to deal with that. But it should not happen, and we should know what's going on because our judges don't own those jobs. They're accountable to the people, and the people should know what they're doing.
I agree.
Because that could be your loved one, and if that's your loved one, you know, when it's our own loved one, we want the process to be fair. If it's not, we don't care. But we have to keep the process fair for everybody. Let's take another call. Caller, you're on.
Pardon me?
You're on. Thank you for calling.
How you doing? You made a regular listener and a regular person to your program. This is Grady.
Hey, Grady, how are you?
Good. I have one question. When judges play those types of games, because I've seen it before, when judges play those types of games, what options do you have as attorneys? And I'll just cut off so I can listen to the response.
Okay. Tina, I'll let you take that first.
Well, options. It depends, Grady. You can do nothing. Obviously, you can go to the media. You can talk about it through the Code of Judicial Conduct, which is the branch that actually disciplines judges' conduct.
You can vote him out. You can.
Unfortunately, your vote alone won't do that.
Yeah, no, right. You can vote him out. One of the things we can do is appeal it, really, and object. Things happen in this trial that were done in closed doors, and that's inappropriate. If it's done in open court with a court reporter, you can object. But the things that happen inappropriately here happened kind of in the back. I mean, there was no court reporter. And so it was just kind of happening. So there is a legal remedy if our client wants to go through with it. We can appeal it. We can write affidavits of what happened, even though it wasn't recorded by the court reporter. So because Rosalyn watched it, she could write an affidavit of what she saw. I can write an affidavit of what happened and ask for a motion for new trial for that, which I think is what we should do, but it's up to the client to make that decision.
Right.
And I think it will be reversed. And the judge, I think, would have to be recused, really.
Can I ask the question?
Yes, ma'am.
Do you have to have that same judge if a new trial was to take place, or how would that work?
Under ordinary circumstances, yes, because the case is assigned to a court, and the court just happens to be held, a court number, and it just happens to be held by that judge.
Court. Okay.
But if the judge has done something we feel is inappropriate, you can file a motion to recuse the judge, which then there is a hearing by a higher judge. The judges actually have a judicial officer that looks over different branches and different regions, regional judges, and he can have a hearing to see that, you know, to decide whether we think he's too biased or not.
Okay.
You can have that hearing, and we do that very rarely, but we do recuse judges, have motions to recuse judges. And it's possible if we appealed this one, we would do that because the judge seemed to be taking that personally. It wasn't appropriate, and it does seem personal. I think that there's I think there's grounds for recusal in this case.
Yeah, because he turned beet red. I mean,
Yeah, he turned beet red.
he did. He turned beet red. I mean, you could see his
When he
demeanor.
saw that note,
yes,
he turned beet red, and he refused to tell the lawyers what the note said, and that's against the rules. I've never seen that happen before. He was so angry that we were winning.
Yeah.
And he wrote did you see how he wrote that note? I mean, and he didn't let us see it. I've never had that happen before. And I've called some appellate lawyers, and they say that is totally inappropriate.
Wow. Yeah.
But we would have to do an affidavit and attach it to a motion for new trial within 30 days of that date. So we still have time.
Good.
So yeah, it was bad. I thought it was very bad.
It was a great experience, but it's nothing that I would want to have to do. And if I did, maybe it would be a better experience for me if I was not related to the defendant. You know what I'm saying?
Right.
Sure.
I mean, but
Because I'm sure as a family member to hear a prosecutor who doesn't know your nephew talk about him like a dog and lie on him, really.
she did. And then what really did it for me, she said, "Send him to jail." I was like, my
And that's inappropriate because that was guilt innocent. That wasn't even punishment.
Her face was construed, and I was like, my goodness, I wanted to punch her myself, but you know. I mean,
well,
but that's
twist, and to twist the facts up. One of the things that frustrated me in closing arguments is when she was saying, well, if it wasn't a kidnapping at the store because our evidence is wrong, and it
changed her mind right in the
oh,
midst
maybe
of
it should be at this point. I mean, that's not that wasn't the facts of the case, and she just kind of tricked the jury.
And that's part of the lie.
That was part of the lie.
That was part of the lie, you know. I mean, I just couldn't believe.
And that's why people need to come and watch juries, because you can see how the prosecutor just basically lies. Mm-hmm. And the jurors are half asleep during 4 days. I mean, they're not paying attention to every detail, because one of the things they wanted to do in this case, they kept asking for all the testimony read back to them. So that means they weren't paying attention, or they were arguing about it.
Sure.
Mm-hmm.
And you can get the testimony read back, but the judge wasn't giving them the form to do it. You have to have an argument about a specific thing, like one of the things that would have been a good one if they would have known how to do this is to say, well, did the medical doctor say that she was run over, or did he not say that? Because she lied and said that. The doctor said he did not know what happened.
He sure did say that.
He said he did not know what happened, but in closing argument, she said she was run over.
Sure.
And so people are thinking, well, that must be what the doctor said.
Sure.
The doctor said, I have no idea what happened. We gave him hypotheticals. If she was on this side, if she was on that side, and everything was couched with hypotheticals.
Sure.
And so people could come away from that thinking that he said that, and that's a straight up lie. She knows it, because a hypothetical is not the truth.
But even with the police officers, it was still hypothetical, because they wasn't there. They didn't even know what happened, so they were just trying to put it together as well. I mean, even when she was questioning the police officers who were part of the investigation, she was trying to construe their thinking as well. You know, it was like
instead
she was
of
trying
letting
to
them be free.
Yeah,
to
you
say
know.
What they
and
saw.
even the paramedic who was the driver in the truck, his whole story was totally different from the partner that took care of the victim. So, I mean, how you do that? You could clearly see that it was tainted.
A motive.
They had a motive to
win.
You.
And I'm going to tell you that in Harris County, our jurors usually are not patient with that. Ft.Bend was a lot patient with that. Our jurors are impatient with prosecutors who, we call that cheating. Because you're just trying to over-prosecute. You're trying to change everything around to be the way you want it, and that's not the way these people are testifying to it, and they were there.
And it was so bad at one point the juror raised her hand to go to the bathroom.
I just want to get out of here.
Yeah, I mean, it was terrible. It was very unprofessional, though. I can't say, and I pride every profession. I don't care if you're a street cleaner. Everybody has a part of professionalism that they should play, and I just think that the whole conduct of the prosecution was totally unprofessional, and even the judge in that aspect, it really was.
Well, I'm getting my cue from the director to wrap it up. So thank you for watching. I know it's kind of a different story tonight because we didn't have the defendant on. He's just a little camera shy right now, so we have his aunt. But thank you for watching. Hopefully we've explained what affidavits do. They mean nothing. They mean nothing. You still have to come and testify and try your case. And the only right a defendant has charged with a crime is to plead guilty and go to jail, plead guilty, get probation, or plead not guilty and confront your accuser. That's all. That's the only rights you have. And hopefully you have a good lawyer that'll investigate it and fight for you. And trust me, this is a very stressful job. Very stressful. Teana, do you have anything to say?
I think that sums it up. Make sure that if you fight, you have a jury of your peers, and you have to get good representation, good lawyers, because you have a system where it's stacked against you.
All right.
And it's so important to have that representation.
All right, I'm getting the final wrap up. Thank you for watching Truth and Justice with Vivian King, and we'll see you next Wednesday.
All right.
Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where